welcome to Crime in Court. My name is Heather, and this is another update in the Canton cover up series Commonwealth versus Karen Reed and Turtle Boy. Today we're going to be talking about Karen Reed. This is episode 81. The ACLU calls out Cannone's errors. So, as you can see by the title of this episode, the ACLU has stepped in to this appeal. So Karen, as you know, Karen is appealing counts 1 and 3 because the jury, at least 6 individual jury members, have said publicly that they did acquit her on those charges. So they are appealing that with the SJC and the Supreme Judicial Court of Massachusetts, and the filings were just due, I believe, yesterday or today. So the Commonwealth did file theirs. We'll read through that in the next episode. But in today's episode, we're going to read through the ACLU's filing. So they put forth this filing. Basically, the ACLU, Civil Liberties Union, they of Massachusetts in particular, they they can basically enter like a filing for the court, which is what this is, the amicus curiae, or an amicus brief. So it is basically they're saying like we are a separate third party that can shed some light on this topic. We have some case law that can be helpful for the courts to decide whether or not they're going to grant this appeal. So it's like a free thing that they just do. They get involved in certain cases where they really feel that the their civil liberties are at risk or being trampled on. So that is the case in this situation. As we all know, Karen Reed's civil liberties have been trampled on, stomped on, thrown away, discarded, in over and over and over again. Turtle Boys too, by the Commonwealth. So let's get started with this. This is a brief of amicus curiae, like I said. So it is basically a filing of put this in your hat for information so that when you make a decision, you are better informed, basically. Amicus curiae of the American Civil Liberties Union of Massachusetts. Let me skip down a couple pages because they've got all this stuff here. Common contents, table contents. All right, so this is their corporate disclosure in Rule 17C5 statement. Pursuant to Supreme Judicial Court Rule 121, the American Civil Liberties Union of Massachusetts, or otherwise known as ACLUM, is a nonprofit corporate. My brain keeps mashing all these words together. Sorry, let me slow down. The ACLUM is a nonprofit corporation organized under the law of Massachusetts. The ACLUM does not issue any stock or have any parent corporation, and no publicly held corporation owns stock in ACLUM. So there's no risk of like somebody paying off the ACLU for this, or their public entities. They're you know what I'm saying. So they're just doing this kind of out of the kindness out of their own hearts. Well, that's what they do. So no party or parties counsel authored the brief in whole or in part. No party, parties counsel, or any other person or entity other than the ACLUM, its members, or its counsel contributed money that was intended to fund the preparation or submission of the brief, which I saw someone post, Turtle Boy had posted something on X about this, and somebody posted on it as a reply, like, so Turtle Boy paid for this, for the ACLU to write this, right? Because the jurors thought that he had hired the ARCA experts who, no offense, but I don't think Turtle Boy could afford them because they are like number one in the world on accident reconstruction. Anyways, so no party or parties counsel authored the brief. Um, the ACLUM and its counsel do not represent and have not represented one of the parties to the present appeal in another proceeding involving similar issues, and we're not parties in and did so they're not a party. They have nothing to do with this. They're just giving their opinion. They're just trying to help out, basically. They have no interest in this. So the interests of the amicus curiae, the ACLUM is the Massachusetts affiliate of the National American Civil Liberties Union. The ACLUM is dedicated to protecting and advancing the civil rights and civil liberties of all people in the Commonwealth, including those guaranteed by the Constitution and the Bill of Rights. Oh, where did I missed a footnote here. Sorry, let me back up. So prior to seeking leave to file this brief, the ACLUM asked counsel for Ms. Reed, the appellant, and the Commonwealth, who is the appellee, whether they would assent to or oppose ACLUM's motion to file this brief. Appellant's counsel assented, and the Commonwealth took no position. That's interesting. That's very interesting that the Commonwealth, I'm gonna highlight that as I like to do. Commonwealth took no position. Okay. All right. So the ACLUM frequently engages in litigation and other advocacy to protect the rights of people involved in the criminal legal system. As part of that work, the ACLUM has filed many amicus briefs before the Supreme Judicial Court. A brief for American Civil Liberties Union, blah, 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 blah. Okay, we don't need to read through all of that. So their sources. Here, ACLUM takes no position on what the evidence presented at trial did or did not show. So they're not saying one way or another whether they think the evidence shows guilt or innocence. Rather, this brief addresses the trial court's decision not to respond to compelling evidence that there was a potential mistake or misunderstanding concerning the outcome of the jury's deliberations. So I'm going to highlight that because I think that's a good sentence there. So there was a potential mistake or misunderstanding concerning the outcome of the jury deliberations and what process will be employed by trial courts addressing any similar circumstances in the future. So something like this could potentially happen in the future again, and this needs to address that. So, introduction and summary of argument. Defendant appellant Karen Reed faces the possibility of being retried on multiple criminal charges for which numerous jurors now claim they acquitted her. A retrial on acquitted charges would violate the prohibition against double jeopardy, a critical right enshrined in the Fifth Amendment to the United States Constitution and Massachusetts common law. If the court does not grant appellant's request relief to dismiss or otherwise preclude the counts on the current record, then this court can and should prevent the potential for injustice by ordering the trial court to conduct an evidentiary hearing and determine whether the jury in her first trial agreed to acquit her on any count. So they are basically saying here Judge Cannone got it wrong and she should have ordered the jury back, asked them questions. Did you acquit her? Yes, no, okay, moving on. We can decide what to do after that. But why she didn't even bring them in makes no sense to anyone. Such that it was not manifestly necessary for the trial court to declare a mistrial. So there was no manifest necessity as they keep trying. So it wasn't necessary to call the mistrial because you had other options at the moment. This brief provides the court with additional context regarding the justifications for an evidentiary hearing into a lack of manifest necessity. At appellant's first trial, the court declared a mistrial on all three counts after receiving notes indicating jurors were struggling to reach a unanimous verdict. But the court did so without polling jurors to confirm they were deadlocked on all counts, or even asking the parties whether they consented to a mistrial or wanted the jurors polled. So none of that was done, and that is all what they are saying is error. Soon after that hasty mistrial declaration, multiple jurors reported that the jury had actually agreed to acquit appellant on counts 1 and 3. And so we're only deadlocked on count 2. Appellant promptly moved the trial court to either dismiss counts 1 and 3 or, at minimum, conduct a post verdict evidentiary hearing to assess the truth of the jurors' reports. But the trial court denied the motion to dismiss and refused to conduct a hearing, leaving open the possibility of appellant being retried in violation of her right to be free from double jeopardy. So, I mean, pretty clear and concise the way they said that. She's, yeah, they went through all the steps and, everything that happened, giving us the background as to how we got here to why we're at the appellate court. The trial court erred. I'm just going to highlight that part because I really can't stand Cannone. The trial court erred in refusing to conduct an evidentiary hearing. The double jeopardy clause protects a defendant's fundamental right against successive prosecutions from the same offense. So she shouldn't be tried again, over and over again for the same thing. The right is deeply rooted in our nation's history and legal system and has been vigorously enforced by both the United States Supreme Court and this court to avoid improper successive prosecutions. The Double Jeopardy Clause requires that courts carefully consider alternatives to declaring a mistrial and to make such a declaration only after finding a mistrial to be a manifest necessity. A failure to do so can bar re-prosecution on double jeopardy grounds. The trial court had a clear path to avoid an erroneous mistrial. Simply ask the jurors to confirm whether a verdict had been reached on any count. So she could have easily avoided all of this confusion, all of this, everything, dragging it out, which I think she likes doing, to drag out Karen Reed's money and time and stress. So there's that. She could have easily dealt with this right away when it happened. She ignored all the motions when the jurors were coming forward with affidavits and the defense was coming forward with affidavits asking for this to be looked at, and she could have brought them in. It wouldn't have been much. It wouldn't have been difficult for her to do. She just ignored it, and now we're at the Supreme Court level. Asking those questions before declaring a mistrial is permitted, even encouraged, by Massachusetts rule. So, it's not just allowed, but we want you to do it. Such polling serves to ensure a jury's views are accurately conveyed to the courts, the parties, and the community, and that defendants' related trial rights are secure. It is also consistent that with a nationwide practice of polling jurors to ascertain verdicts, including before declaration of a mistrial. So it is okay to do so. And it's the nationwide practice to do so, poll them before declaring a mistrial. Here, a post-trial evidentiary hearing would serve the same purposes, enabling the trial court to determine whether the jurors had actually agreed to acquit appellant on counts 1 and 3, such that it was not manifestly necessary for the court to declare a full mistrial. Accordingly, an evidentiary hearing is required to safeguard appellant's rights under the Double Jeopardy Clause, and the court should order the trial court to conduct one. So, Supreme Court should order the trial court to conduct an evidentiary hearing. That is what they are recommending. Number 1. The prohibition against double jeopardy is a fundamental constitutional right that protects against the burden of multiple prosecutions. The Double Jeopardy Clause of the Fifth Amendment provides that no person shall be subject for the same offense to be twice put in jeopardy of life and limb. We have a footnote here. The Double Jeopardy Clause has been incorporated against the states through the 14th Amendment. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. And that is what they are doing, is weaponizing the law there. Thus, the Double Jeopardy Clause exists to ensure that the government, with all its resources and power, is not allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity. People don't understand how stressful it is to be litigated. You just want it over. You worry you're going to have enough money to figure things out. You're worried what's going to happen. You're completely, yeah, it is stressful. It's embarrassing if you're being charged for homicide of your boyfriend and you have to go through this trial again. All those embarrassing voicemails and her texts to Higgins and things like that. Like, that never should have had to be dragged out so publicly. But they really wanted to not just prosecute her, but persecute her. And I really think that they're weaponizing and coming at her hard, just unnecessarily. The historical roots of the Double Jeopardy Clause long predate the American founding um, fathers, maybe. Its origin can be traced to Greek and Roman times, and it became established in the common law of England long before the nation's independence. So that's interesting. That has been the whatchamacallit. Moving on. In medieval times, canon law prohibited double jeopardy on the basis that God does not punish twice for the same transgression, and as early as the 15th century, the English courts had began to use the term jeopardy in connection with the principle against multiple trials. This thread continued through Sir Edward Coke's 17th century treatise on the laws of England, which articulated a theory of double jeopardy. Wow, it goes back long, long ways. And in his 1769 commentaries, Sir William Blackstone famously wrote of the universal maxim that no man is to be brought into jeopardy of his life more than once for the same offense. Concerns about double jeopardy crossed the Atlantic with early American colonists. Uh, colonial, col- colonists? I don't know. In fact, the American conceptualization of double jeopardy began with the Massachusetts colony. The 1641 Body of Liberties provided for an expansive prohibition against double jeopardy that extended to criminal and civil offenses. This provision was mirrored and extended in the Massachusetts Code of 1648, which required the express recording of past legal actions to prevent future jeopardy. So there you have it. Massachusetts adopted this code in 1648, or its code of 1648. So, it's been around quite some time. These foundational tenets of Massachusetts law arguably shaped the nation's subsequent adoption of the Double Jeopardy Clause in the Fifth Amendment. So these rules in Massachusetts, it all began in Massachusetts in our country. I mean, it began a long time ago, but it was brought to Massachusetts, and that's where it started. This double jeopardy clause, this double jeopardy rule. It was eventually adopted by nationwide later on for the Fifth Amendment. So while enactment of the Double Jeopardy Clause was relatively uneventful, Early American jurists quickly recognized its importance. In 1824, Kentucky Supreme Court opinion referred to the prohibition of double jeopardy as a wise rule so favorable and necessary to the liberty of the citizen. An 1833 decision by the New Jersey Supreme Court observed that this great principle forms one of the strong bulwarks of liberty. And in 1843, Justice Joseph Story called the Double Jeopardy Clause a constitutional recognition and that fundamental rule of the common law, which has been recognized by elementary writers and courts of justice from a very early period down to the present times. Um, what else? Okay. In modern times, the Supreme Court has recognized the fundamental importance of the Double Jeopardy Clause by expanding its scope. Notwithstanding the text of the Fifth Amendment, double jeopardy protection extends to all crimes, capital or otherwise, and the existence of an acquittal is a question of federal, not state law, with a constitutional floor that prevents the states from impeding a defendant's double jeopardy rights. So even though the Massachusetts might say, we want to try her again, federal law can prevent them from doing so. Jeopardy also attaches when a jury is impaneled and sworn in, not when a verdict has been given. That's kind of important. So double jeopardy started from the moment the jury was sworn in. So at any time, any point in time during the trial, if something were to have happened, double jeopardy attaches, and she would not have been tried again if she got acquitted or something along those lines. So finally, as relevant to this case, the Double Jeopardy Clause can bar retrial even when the first trial ends in a mistrial with no acquittal or conviction. For even if the first trial is not completed, a second prosecution may be grossly unfair and burdensome to the defendant. Moreover, the defendant has a valued right to have his trial completed by a particular tribunal or chosen jury, such that only the showing of manifest necessity will allow a trial court to declare a mistrial without barring a retrial of double jeopardy grounds. The decision to declare a mistrial without a defendant's consent is only justified by a high degree of necessity and requires a scrupulous exercise of judicial discretion. In Massachusetts, where there is no specific constitutional protection against double jeopardy, but where the common law protection thereof may be greater than either the state or the federal constitution requires, the declaration of a mistrial requires the trial court to both provide defendant's counsel with a full opportunity to be heard, which also did not happen, and carefully consider alternatives to a mistrial, which didn't happen. Together, the above resources sing a simple but powerful melody regarding the importance of the right against double jeopardy in criminal proceedings, which is deeply ingrained in the Anglo American system of jurisprudence and bolstered by recent precedent. Accordingly, when the government asserts the power to retry a defendant who has already gone through the burdens of one full trial, as is the case here, courts must safeguard the defendant's fundamental rights by carefully scrutinizing that assertion in light of all available information. Point number 2. Trial courts regularly poll juries both after a verdict is announced and before a mistrial is declared. So she should have polled the jury twice, at least, and she did not. So in her motion to dismiss, appellant asked for a post-verdict evidentiary hearing to determine whether the jury had agreed to acquit her on counts 1 and 3. The Commonwealth opposed this request as improper, as if, bringing them in would be improper, which is not. And the trial court rejected it as prohibited, which it's not. But the propriety, I don't know why for a second I had a brain fart there where I couldn't pronounce that. But the propriety and sometimes necessity of inquiring about the outcome of a jury deliberations is confirmed by the fact that trial courts regularly poll juries on verdict related issues. So you are allowed to poll juries on verdict related issues. You don't have to ask them how they got to their verdict, but you can ask them, was this your verdict? That wouldn't be against the rules. Massachusetts courts frequently poll juries to determine whether the announced verdict was correct. Consistent with Massachusetts procedural rules, courts in this state and others also poll juries to determine whether deadlock exists or if future deliberation would be useful. Massachusetts Guide to Evidence Section 606B and Rule of Criminal Procedure 27D both allow the court to poll juries after a verdict has been returned. Granted, it is within the trial judge's discretion whether to poll the jury, so it is within their discretion. But there are times when a judge should use their discretion accorded by Massachusetts law to poll a jury after the verdict is returned. For example, in Commonwealth versus Nettis, the trial court properly conducted a poll of the jury when one juror indicated her disapproval of the announced verdict. As with the evidentiary hearings discussed above, the court's polling of juror votes does not impermissibly intrude into the jury's deliberative process. So it's allowed. You can ask them what their verdict was. The court's polling of jurors does not impermissibly intrude in the jury's deliberative process, which is what the state is claiming that is what is happening, that you're infringing on the sanctity of the deliberation process, and it's not. So they're just being disingenuous. Federal trial courts have also polled juries to determine whether they are truly deadlocked ahead of a mistrial declaration. In United States versus Barbioni, the jury deliberated for 10 hours but could not reach a verdict. Before declaring a mistrial, the district court polled each juror individually and with great care. All stated that the jury was deadlocked and not likely to reach a verdict. On appeal, the first court found these actions supported manifest necessity for a retrial. Many other federal courts have also polled individual jurors to ask whether a deadlock exists before declaring a mistrial. So you are to poll them before the deadlock or before declaring a mistrial. Sorry. Poll them before the mistrial, which is not what she did. She just went straight to mistrial. Okay, you're excused. See ya. Bye. You're out of here. State trial courts have likewise polled jurors ahead of mistrial declarations in order to determine whether manifest necessity exists. In State versus Jandro, the jury sent 3 notes that indicated potential deadlock. The trial court individually polled the jurors after each note to determine whether deadlock truly existed. On appeal, the Maine Supreme Court characterized this effort as thorough and appropriate to determining whether a mistrial was manifestly necessary. So, to even determine that there was a manifest necessity to call the mistrial, you have to poll the jurors to be thorough and appropriate. I mean, we get it, right? Judge Cannone is the one that and the Commonwealth, they don't get it. Other state courts have exercised similar care to thoroughly assess whether a mistrial was necessary. And they list a whole bunch of different sites or resources. This kind of pretrial polling is not only permitted under Massachusetts law, it is encouraged. Again, not just permitted, but encouraged. Under Rule of Criminal Procedure 27B, a court intending to declare a mistrial may ask the jury return verdicts on those charges upon which the jury can agree. So the court may ask to return verdicts, partial verdicts, if they can, which she didn't even give any instruction on partial verdicts. Her instructions, if you look back at them, they are not geared for someone who has multiple charges. The instructions that she read, I believe she deliberately read the charges of someone who was only facing one charge because it didn't have any instruction on what you're supposed to do if you find her guilty or not of another charge. So it's very scary that she has the power and can just make you think something else and lead it to a mistrial if that is indeed what she did. And I have a feeling she did. The reporter's notes to uh, rule to the reporter's note to Rule 27B states even more definitively that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. I'll read that again. It must first receive and record the verdicts which the jury can agree upon. And I missed a footnote somewhere. It says some courts have gone even further. For example, in Halverson, the jury was potentially deadlocked on the punishment for one count. After asking the jurors whether additional deliberation would be useful, the trial court specifically asked where the jury was leaning numerically. The California Supreme Court concluded that the judge's actions supported his later declaration of a mistrial. So you can even kind of ask them, where are you leaning? And it is not violating anybody's rights there. Thus, Massachusetts law expressly enables judges to poll juries ahead of a mistrial to determine whether a full or partial mistrial should be declared. That fact supports appellants' requested evidentiary hearing because such a hearing would achieve the same goal as polling, i.e., for the court and the parties to receive an accurate assessment of the jurors' conclusions without probing the subjective mental processes of jurors, such as the reasons for their decisions. That's what we have been saying from the very beginning when this all came to light. It's not it's not against their own code to not ask about deliberative processes. You are able to do so as long as it is asking about the verdict, not the deliberation process itself. All right, third point that they make is trial courts also routinely hold post-verdict evidentiary hearings to address irregularities in jury proceedings affecting constitutional rights. The propriety of appellant's requested post-verdict evidentiary hearing is also supported by Massachusetts precedent, which allows for post-verdict evidentiary hearing that inquire into irregularities with jury proceedings that affect constitutional rights, including double jeopardy. The rule allows for this, so there's no reason she should not be bringing them in. The most prominent example of such post verdict hearings implicates the Sixth Amendment right to an impartial jury. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Trial courts may conduct a post verdict evidentiary hearing where evidence suggests that extrinsic influence may have had an impact upon the jury's impartiality. The refusal to do so can itself constitute reversible error. So, just the fact that she's not bringing them in is a reversible error. And where the case is close, courts should exercise discretion in favor of conducting a judicial inquiry. In favor of conducting an inquiry. If you are unsure, it's just why? What does it hurt to bring them in and ask them? Did you acquit her on counts 1 and 3? Yes. Okay, next. Did you acquit her on counts 1 and 3? Yes. Next. That's all she needs to do. Just don't understand. Thus, trial courts regularly hold evidentiary hearings to determine whether extraneous influence had an impact on the jury's impartiality. Did I read that? And the refusal to hold a hearing to consider extraneous influence has frequently resulted in reversal on appeal. So I love that they are calling Judge Cannone out for you didn't do these things and you're going to be reversed. These things are going to be appealed. Um, Evidentiary hearings have also been held to determine whether a jury's verdict was unanimous as required by Massachusetts Rule of Criminal Procedure 27A and as relevant for purposes of the Double Jeopardy Clause, since a prior acquittal or conviction bars a retrial for the same offense. In Commonwealth versus Brown, the jury foreman claimed that the verdict was erroneous, and the trial court held an evidentiary hearing wherein the jury corrected its verdict on appeal. This court found no impropriety in the trial court's actions. In Commonwealth versus Diaz, a juror told the trial court that she did not agree with the verdict. The court interviewed the remaining deliberating jurors, the court officers, the clerk of the court, and any personnel who had knowledge about about the rendition of the verdict in the case before declining to disturb a verdict. In the wake of this investigation, this court affirmed the lower court's denial of the defendant's motion for a new trial. Additional cases from this and other jurisdictions affirm the ability of courts to conduct such proceedings and take corrective action regarding jury verdicts. To be clear, such inquiries need not reach the content of the jurors' deliberations or the particular reasons for their decisions. There is no obstacle to a trial court taking evidence as to the outcome of the jury's deliberations. There's nothing impeding them from calling them back in and saying, did you come to this conclusion? Yes or no? Not how did you get there, but did you get there? Given the reporting that such information is fundamentally the purpose of the jury. I mean, true, the jury is supposed to come to a verdict if they can, and that is their whole entire purpose of being there. So for her to just dismiss the jurors as she has so easily, the 6 jurors that have said publicly that they acquitted her, it's pretty, um, I would be offended. And if I were a juror and in that position and like screaming from the rooftops, hey, we acquitted her, but Judge Cannone was ignoring us, I would be extremely upset about that. Having served that many weeks, it ended up being like 8, 9 weeks, I think, with because they had so many days off and whatnot, it stretched out for so long. And they gave up that time. And for her to just dismiss them so easily just shows you what she thinks of them. Through such an inquiry, the court can determine the jury's decision, which necessarily bears on whether the robust protections of the Double Jeopardy Clause will apply. Fourth point, the trial court should be compelled to conduct an evidentiary hearing given reports from jurors that the jury agreed appellant was not guilty on counts 1 and 3, such that the court did not have the manifest necessity to declare a full mistrial. In this case, after receiving a third note from the jury indicating difficulty reaching a completely unanimous verdict, the trial court declared a mistrial on all counts and set the stage for a full retrial. But as appellant's brief cogently describes, her attorneys soon received multiple reports from jurors, in some cases via intermediaries, and the jury had unanimously agreed to acquit on counts 1 and 3. Juror A stated that the jury unanimously agreed to acquit appellant on counts 1 and 3. Juror B believed that every member of the jury, if asked, would confirm that the jury agreed to acquit. Juror D said that every one of us will agree and acknowledge that the jury found appellant not guilty on counts 1 and 3. Juror E confirmed that the jury was unanimous on counts 1 and 3. The Commonwealth also received communications from individual jurors about the jury's agreement on the first and third counts. It is thus unsurprising that the trial court accepted the jurors' statements about this agreement as true and accurate. And we know that they even called the Commonwealth. I mean, that's what they just said there. The Commonwealth received these communications. So it is fact that these jurors were trying to come forward and tell us that they acquitted her. They contacted both the defense and the Commonwealth. Given such overwhelming evidence of the jury's agreement on counts 1 and 3, a post verdict evidentiary hearing must be ordered to determine whether the jury decided to acquit appellant on any counts, such that the trial court did not have a manifest necessity to declare a mistrial. Such a hearing is warranted to assure the sanctity of appellant's right to be free from double jeopardy, a fundamental right which is wide in scope that is deeply ingrained in our legal system. In the area of manifest necessity and mistrial, this court encourages that fundamental right by requiring the careful consideration of alternatives to a mistrial. And the nationwide practice of polling juries before mistrials are declared. The trial court could have avoided the instant controversy. I'm going to repeat that. Judge Cannone could have avoided the instant controversy by polling jurors individually before declaring a mistrial. Unfortunately, it did not, nor does the court reflect that the parties were given an opportunity to request or express their views on whether polling was appropriate. In any event, after the court declared a mistrial on all counts, it promptly received reports that its declaration of a mistrial was premised on an apparent mistake or misunderstanding concerning the jurors' conclusions, as in that they were deadlocked on only one count and had actually acquitted on others. At that point, the court not only could have, but should have held an evidentiary hearing to determine whether, in fact, there was manifest necessity for a mistrial, sorry. The court's refusal to do so is a reversible error. I love that they keep saying over and over again, Judge Cannone, you were wrong. There is federal law that supports this, Massachusetts law that supports this. You were wrong. If you didn't want to pull them at the time of trial or you just forgot, you should have done it afterwards when it was brought to everybody's attention. But no, it's her fault that it took this long. She dragged it out. An evidentiary hearing was and remains necessary because a lack of manifest necessity would mean that retrial on counts 1 and or 3 violates appellant's rights under the double jeopardy clause. Because that clause protects against the burden of enduring multiple trials, not merely the possibility of a conviction upon retrial. A violation of appellant's double jeopardy rights cannot be remedied after a second trial, whether or not she is ever convicted. Put another way, if the trial court lacked manifest necessity for a mistrial on counts 1 and or 3, then appellant's double jeopardy rights will be irredeemably violated even if she is someday acquitted of those charges at the subsequent trial. Thus, a wait-and-see approach would potentially permit an irreversible violation of the Constitution, and an evidentiary hearing is necessary now. I love that. We need to know now. We can't wait. We can't wait for the second trial to begin because this is violating her rights now. The trial court denied appellant's request for a hearing because it concluded that such a proceeding would impermissibly intrude into the substance of the jury deliberations. In justifying that ruling, the court said that a hearing would necessarily require the court to understand any supposed tension between the jury's notes to the court and their agreement to acquit the appellant on 2 counts. But that is not so. The trial court is well situated to set appropriate limits on any questioning, and it may only need to ask each juror whether the jury reached a unanimous verdict on counts 1 and 2 or 3. As cases like Span make clear, questioning to confirm or understand what the jury decided does not intrude into the deliberative process, as we've been saying on repeat. In response, the Commonwealth may claim that because post trial reports from jurors A, B, D, and E were not in front of the trial court when it declared a mistrial, a partial verdict was not a reasonable alternative at the time of the court's declaration. But that argument fails for 2 reasons. First, as appellant observes, the jury's communications with the trial court are susceptible to the interpretation that the only deadlock was related to the lesser included offenses of count 2. So the trial court had reason to believe that a poll aimed to return a partial verdict was a meaningful alternative to a full mistrial. You could have read their note one of 2 ways. Second, cases like Diaz and Brown demonstrate that post verdict evidence can support a post verdict evidentiary hearing into the content of the jury's agreement, even if the evidence was not known to the court ex ante, whatever that means. I think it's after trial, probably. Or afterwards. Thus, the fact that evidence suggesting the jury reach a partial verdict arrived after trial does not preclude an evidentiary hearing. The timing also supports the use of an evidentiary hearing as memorialized in attorney affidavits. Jurors began raising concerns about the mistrial the day after the declaration was made, and others quickly followed suit. So there is robust, uniform, and contemporaneous evidence of what the jury agreed to. Supported by the evidence, appellant requested an evidentiary hearing within 1 week of the mistrial. Beyond that, the specific nature of this mistrial context lessens the risk of externally influenced post hoc changes. I think what they're saying here is they should have done it like right away within that week period so that you weren't, exposing the jurors to outside influences and things like that, and you were it was timely, whereas now they could be influenced by external, sources and whatnot. So this is not a situation where a court would be likely to find an agreement to acquit based on one juror's changing view or post-trial misgivings, both because a significant portion of the jury has already come forward to evidence their agreement, and also because all of the jurors apparently remain available to testify. So why not bring them in? After 400 or almost 400 years ago, the Massachusetts colony enacted the first formal prohibitions against double jeopardy on American soil. Again, it started in Mass. In accordance with this tradition, the court should require an evidentiary hearing to ensure that appellant's double jeopardy rights are not violated by a second trial on counts for which the jury already agreed to acquit her and for which the trial court did not have manifest necessity to declare a mistrial. Such a remedy is necessary to maintain the double jeopardy clause and that strong bulwark of liberty, which stands against the devastating and one sided nature of the jeopardy that confronts criminal defendants facing retrial. The conclusion is for the foregoing reasons, this court should vacate the decision of the trial court denying appellant's motion to dismiss and remand for the trial court to conduct an evidentiary hearing if the charges are not otherwise disposed. Signed by Michael T. Packard from Quinn Emanuel Urquhart and Sullivan LLP. And that is it for that. So that was the 16th that came out. We do have the response from the Commonwealth. I'm going to do that in another video. I do have a buzzkill warning from our one of our favorite legal minds, Mr. Mark Betterow. He says, just not to get our hopes up or anything. I think this is the reason why he put this out there, but I had to share it because these were both really funny to me. So, Betterow Law says, buzzkill warning, amicus briefs are very common in appellate practice, including those from the ACLU. Better to have them for you than against you, but I would not assume a favorable ruling is more likely merely because one has been filed in support. So just because they filed this doesn't mean that it's going to necessarily swing the votes from the court, but it is helpful for them to look back at case law. They looked, and from reading that, you can tell the double jeopardy rule started in Massachusetts. It's federal law, so they gave us the whole background on it. So I thought that was pretty good. And then this account, but named Constant Plumbottom says, "Okay, Mr. Honest, remind me to never ask you if I look fat in these pants," which I thought was really funny because he just wanted to bring our hopes down just a little, I think, because he didn't want us to get our hopes up too big. But I thought her response was pretty great. So I will leave you guys with that. Let me know if you have any questions or if you have other angles or things that you want me to bring up regarding the Karen Reed case. I love to get into these deep dive videos. So if you guys have more topics or something that you want me to research further, let me know in the comments below. Thank you guys so much for being here. Please hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.